Thank you for having me here, and thank you for coming, in spite of the fact that this is the end of the semester. So, yes, this is a very fresh thing. I mean, I'm presenting this for the first time, and the talk that I want to give today started as a really, really small part of one chapter of my doctoral dissertation, and now it is growing into a paper on its own. The whole dissertation explores an alternative understanding of federalism and its implications for thinking of democracy, and you can rightfully ask, alternative to what? Well, alternative to the hegemonic idea of the federal state, right? The federal state, like Germany, India, Argentina, or Nigeria, is what people have in mind when we say federalism, right? The general feature of this political and constitutional form is that it has two levels of government, each with its own spheres of competences, with some kind of hierarchy between them, but with one national people who, if we are talking about democracies, are considered the source of political power and the true author of the constitution, or in the words that political theorists and constitutional theorists like myself like to use, the constituent power, right? So according to the typical story, the United States is a paradigmatic example of this kind of a state. And the source of this story, the source of this paradigm is the United States Constitution that opens with the famous words, "We the people," right? While I was doing my research, I noticed that this story is popular, but there are some problems with it. The interpretation of the United States Constitution as the Constitution of the federal state is a contemporary one, and projecting it onto the past is anachronistic. What I noticed, and what I want to argue today, is that the idea of the federal state emerged sometime between the founding and the Civil War during the debates regarding the nature of the US Constitution, and particularly about the nature of we the people and what this phrase means, right? The meaning of we the people was shaped by different ideas about the relationship between the people and the people of the United States and the peoples of the individual states, and the relationship between them and state and federal constitution. Besides the difference regarding the who of constituent power, these different interpretations differed also when it comes to the how, right? Meaning in the way the Constitution was created. The meaning of "with the people" also had implications for the understanding of the explicitly expressed goal of the Constitution, that is to form a more perfect union. So as a result of the debates that I will review, the concept of the federal state was shaped and its defining features were developed, right? And its defining feature is not, as some might claim, the institutional setup of the government or a locus of sovereignty understood as an ultimate decision-making power, but the nature of the constituent power and its relation to the government, right? So the concept of the federal state emerges in a polemical context against and in contradistinction to what will become known as confederation, and understanding of this background is crucial precisely because political concepts are always polemical concepts. This polemical relationship between the federal state and the confederation eventually created a binary distinction between the two, that has important implications for how we think and we do not think about democracy today. And I think that this conceptual reconstruction can also help us offer some hypotheses about contemporary American politics. So in reconstruction of the birth of the concept, I will not trace all minute changes over time. I will apply what David Armitage calls serial contextualism. By serial contextualism, I mean the reconstruction of a sequence of distinct contexts in which identifiable agents strategically deployed existing languages to effect definable goals such as legitimation and delegitimation, persuasion and dissuasion, consensus building, and radical innovation, for instance. right? So to deliver my point, I will focus on two junctions, and I will analyze how different interpretations of the US constitutions were deployed and how the constituent power was conceptualized, and to anticipate potential criticism that these theoretical and conceptual developments were only cynical attempts to justify actions by people motivated solely by their interests. I would like to offer the quote from German sociologist Max Weber, right? Interests, both material and immaterial, not ideas, immediately dominate actions of men. But the images of the world that ideas create often determine, like switches, the tracks along which the dynamic interplay of interests drives human action. In other words, ideas matter because they shape what we considered an appropriate course of action, they shape what we consider doable, and what we consider preferable. So my talk will proceed as follows. First, I will present the disagreements regarding we the people at the time of the ratification of the US Constitution to show that there was actually disagreement about that. Then I will talk about two junctions that are critical for the development of the context of the of the concept of the federal state. And each junction I will follow two emblematic figures in their contributions. The first junction is the nullification crisis. And here I will discuss John C. Calhoun and Daniel Webster. And the second junction is the secession crisis, and here I will discuss Jefferson Davis and Abraham Lincoln, right? In the last part of the talk, I will conclude, meaning I will more formally reconstruct the concept of the federal state, explore the consequences of its birth as a polemical concept for our thinking about democracy, and offer some ideas about contemporary American politics, right? So I assume that all of us know how the American Constitution came to be, but at the risk of stating the obvious, let me give a very brief background for the debates regarding the Constitution, right? So the crucial thing here is the passage from the Articles of Confederation to the Constitution. Articles of Confederation established a union between several states, but the only organ of this union was the Congress. It was weak vis-a-vis the states. It had problems executing its powers. For many reasons, Americans decided to amend the Articles and called for a special convention to do this, the Philadelphia Convention. However, the participants of the convention decided that they will not draft amendments to the Articles, but they decided to write an entirely new document. What emerged from this was a proposal of a government that had its proper legislative, proper executive, powers of taxation, and so on and so forth. And this document famously opens with the words, "We the people." But it is not clear what "we the people" means, right? And it's not clear for the proponents of the Constitution. And I mean, it shouldn't be surprising that there is a disagreement between the opponents and proponents of the Constitution. But the proponents of the Constitutions themselves did not agree on that, right? So the first quote, right, is from John Jay, Federalist number 2. To all general purposes, we have uniformly been one people, each individual citizen everywhere enjoying the same national rights, privileges, and protection. As a nation, we have made peace and war. As a nation, we have vanquished our common enemies. As a nation, we have formed alliances and made treaties and entered into various compacts and conventions with foreign states, right? So for him, this unity, it kind of implies that for him, this unity of the American people needs an expression in the unity of the Constitution and the government that it creates, right? I mean, but when you go a little bit further, right, there is Federalist number 39, written by James Madison. Constitution is to be founded on the assent and ratification of the people of America. This assent and ratification is to be given by the people not as individuals composing one entire nation, but as composing the distinct and independent states to which they respectively belong. It is to be the assent and ratification of the several states derived from the supreme authority in each state, the authority of the people themselves. The act, therefore, establishing the Constitution will not be a national, but a federal act. This disagreement was not trivial, because it had various implications. For people like Jay, the Constitution was the supreme law of the land, ordained and established by the people of the United States. The synonyms of to ordain are to command, to order, to decree, from above, in a way, to impose. For Madison and people like him, it was a compact in which peoples of states agreed to create one constitution, create a common government, pledge mutually to abide by the Constitution. And in this sense, it was not a command or it was not commanded or ordered. In this sense, Constitution was agreed on. Crucially, this was only one of the many issues that that people disagreed on, right? Federalist number 39 that I already quoted lists many more dimensions along which Constitution can be judged, primarily the institutional aspect of the new government. Federalists and Anti-Federalists disagreed to a large extent about the scope of the competences of the new government. The constituent power and the nature of the constituent power was just one of many things they disagreed on, right? And in this sense, it was kind of swamped or covered up by those other disagreements, right? It changed once the Constitution was ratified, right? All issues regarding the institutional aspects had been rendered moot, and the only issue that remained unresolved, and as it turned out, was the nature of the constituent power, right? So here we are at the first junction, right? And the first junction is the nullification crisis. Let me give you a very brief background, right? So the nullification crisis started with the tariffs of 1828, right? At that time, the federal government wanted to protect northern manufacturers, so protective tariffs were imposed. South Carolina protested because it perceived those tariffs as punitive for them. It was, from the perspective of South Carolina, it was not the protection of northern manufacturers. It was pursuit of interests of northern manufacturers at the expense of the agricultural South, right? So in 1832, a new bill is passed. This one is not accepted by South Carolina neither, and here we are in a critical situation because South Carolina decided to nullify federal legislation, meaning to render it unilaterally null and void within the borders of South Carolina, right? And here enter two giants, so to speak, of Senate debates, Calhoun and Webster, right? So the theory of nullification was based on, was developed by John C. Calhoun, and in his famous Fort Hill address, right? He said, I quote, "The right of interposition, be it called what it may, state right, veto, nullification, or by any other name, I conceive to be the fundamental principle of our system," right? It is not one of the many, right? It is a crucial tool of the state to defend its interests. Nullification means the right to deem a piece of federal legislation unconstitutional. And where did Calhoun take this idea from? From his conception of constituent power, right? from his compact theory of the Constitution, which he summarized in the same address in the following manner. The great and leading principle is that the general government emanated from the people of the several states, forming distinct political communities and acting in their separate and sovereign capacity, and not from all of the people forming one aggregate political community. That the Constitution of the United States is in fact a compact to which each state is a party in the character already described, right? In the character already described, meaning sovereign character. It looks like he's following Madison, but he's taking the compact theory one step further, a step that Madison was not willing to take, because in his interpretation, the states only delegate some powers to the general government to act in concert, and they remain separate. This means that they retain sovereignty. The states, in Calhoun's words, are the ultimate judges of wrongs inflicted on them and the means of redress. Nullification is precisely the exercise of sovereign power. It is a veto power to arrest the actions of the government that are deemed by the state a violation of the Constitution, right? And the state can do it unilaterally on its own without asking anyone, because all parties to the compact are equal. And since they are equal, there is no independent judge above them. So each can judge for itself, right? And it does not matter that none of this is in the text of the Constitution, right? What matters is that it follows from the logic of the compact, right? Of how of the Constitution, right? So Webster flatly rejected it. And he rejected the compact theory of the Constitution. In his brilliant speech from 1833, in response to Calhoun's resolutions that mirror the thesis from Fort Hill Address, Webster says the following: "The state constitution are established by the people of the states. This constitution is established by the people of all states. How can a state undo what the whole people have done? How can she absolve her citizens from their obedience to the laws of the United States? How can she annul their obligations and oaths? How can the members of her legislature renounce their own oaths?" In this sense, right, the Constitution is established by the unified people, right, of the United States, taken as one collective macro subject. And this Constitution creates a direct relationship with individuals, and individuals have obligations to follow the law, and the state cannot nullify federal legislation because it is not a party to the relationship between individuals and government, right? And Webster says, as it is a government, as it has a legislative power of its own, the inference is irresistible that this government, thus created by the whole people and for the whole people, must have an authority superior to that of the particular government of any one part. Again, it looks like he's drawing on some familiar notes, but just like Calhoun in relation to Madison, he introduces an important change, right? States are inferior because they are established by a part of a whole, and this part does not have any independent existence, right? So in order to understand it a little bit better, I prepared a visual aid, right? So on the left, you have Calhoun with it's a brief scheme of his constitutional theory in one picture. So at the bottom, bright brown or yellow, I don't know what color it is on the screen here, are state peoples at the bottom and state constitutions at the top. Dark brown is the same but in relationship to the federal constitution. So you can see that separate states-peoples create separately state constitutions, and state-peoples create federal constitution jointly, right? But not as one subject. Webster, on the other hand, for Webster, there's just one collective microsubject, the American people, who creates both, right? In Calhoun's case, the United States, in other words, is a collection of peoples of individual states, right? In the case of Webster, the relationship between the states and the peoples of the states and the people of the Union is significantly different. The latter, meaning the people of the Union, is not only composed of the former, but it also contains it, right? So how was this debate resolved? Actually, it wasn't, and this was one of the problems. The thing is that after South Carolina nullified the federal legislation, the President of the United States at that time was authorized by the Force Bill to use military to enforce tariffs. Things were heading to a bloody confrontation, which was averted only because politicians on both sides, including John C. Calhoun, worked very hard to avoid war. Eventually, an amendment to the tariffs was passed, and this was acceptable for South Carolina. South Carolina revoked its nullification of tariffs, but then nullified the Force Bill, right? And this nullification was just left, this nullification of the Force Bill was just left hanging. But I don't think that it was symbolic and inconsequential, or symbolic in the sense of inconsequential, because it clearly shows that in this particular case, through some compromise, only one instance of a conflict was resolved and confrontation was averted, and the underlying theoretical disagreement was not resolved, right? Now, fast forward about 25, 30 years, and we go to the second junction, right? In order to understand what happened in between, right, we need to understand that the tariffs, fortunately, at that time, were not all or nothing question, right? There can be zero tariffs or tariffs so high that they are absolutely unacceptable, but between those two poles, you have a plethora of opportunities. You can have tariffs that are too high not to complain, but too low to actually start a civil war over that. And this is what happened, right? The thing is that between the nullification crisis and the civil war, one of the conflict that surfaced, right, gained prominence, was conflict over slavery. And the problem with slavery is that it's not, it is a all or nothing question, right? One of the, examples can be that you cannot be partially a slave, right? But it's it's not a serious argument in this context. In this context, right, what matters is that because of the expansion, the question of slavery was increasingly thorny for both North and the South, right? The question was what to do with slavery in newly acquired territories, right? Because the 3/5 compromise established precarious equilibrium between the North and the South, but it was not. But this equilibrium was upset by the expansion, right? And the North wanted to contain slavery, the South wanted to expand it, and the contradictions accumulated. And in 1857, we have a Dred Scott decision, which one of the implications of which was that slavery was legal in the entire United States. And in response, Republicans mobilized openly against the ruling and openly on anti-slavery platform. And in this context, the confrontation between Jefferson Davis and Abraham Lincoln takes place, right? One of the important differences between the North and the South is that the North thought that, or was convinced, that slavery was local and freedom was national. But the South thought completely, the other way around. Slavery was national, freedom was local, right? So, apologies for a long quote, but I think it is important in this context, right? So, this is a quote from the Resolutions on the Relations of States submitted by Jefferson Davis in 1860, right? When abolitionist and Republican agitation is very high, and Southerners are a little bit concerned about the possibility of a presidential victory of a anti-slavery candidate, right? So the resolution reads: "The Negro slavery, as it exists in 15 states of this union, composes an important portion of their domestic institutions inherited from their ancestors and existing at the adoption of the Constitution, by which it is recognized as constituting an important element of the apportionment of powers among the states. Attacks on slavery are in manifest violation of the mutual and solemn pledges to protect and defend each other given by the states respectively on entering into the constitutional compact which formed the Union, and are a manifest breach of faith and a violation of the most solemn obligations. What this long quote means is the following. Slavery existed before the Constitution in some of the states. States entered the compact of the Constitution to protect their domestic institutions, including slavery. The compact was a mutual pledge and promise of states to each other to help to protect the domestic institutions. This applies to slavery as well. And this means that any attack on slavery is in violation of the Constitution, right? Effectively, right, the Constitution is a compact between sovereign states, but more importantly, it's a compact between slave states and free states. And because it's a compact between slave states and free states, it requires preservation of slavery. And if expansion of slavery is required for its preservation, then it requires expansion of slavery into the West. The implications of that are very profound, and they extend much further than nullification, right? Attacks on slavery do not consist of actions that can be nullified, right? Because they occurred outside the boundaries of slave states, right? It was anti-slavery agitation in the North, anti-slavery petitions to Congress, attempts at restricting slavery in new territories and states, or the election of an anti-slavery president. Right? The implication is that the North has to restrain itself and agree not to exercise of some of its ostensible rights, like the right to petition to the Congress or the right to free speech, to adhere to the spirit of the Constitution. But the question is obviously, what if the North does not self-restrain? What if, say, they elect an anti-slavery president? What is the proposed solution? Right? It is clear from Davis's speech before the Mississippi legislature from '58, if an abolitionist be chosen a president of the United States, I should deem it your duty to provide for your safety outside of a union with those who have already shown the will and would have acquired the power to deprive you of your birthright and to reduce you to worse than the colonial dependence of your fathers. The solution, in other words, is secession. Importantly, it is not the right of the oppressed after experience of oppression. It is the right in anticipation of a potential oppression. Right? Mind you, it's not 1858, so it's not even an election year. Right, and where does this come from? This right to secede come from? Well, indeed, it is obvious that under the law of nations, this principle, that is the right to secede at will, is an axiom as applied to the relations of independent sovereign states, such as those which had united themselves under the Constitutional Compact. This means that the right to secede is legal, and it comes from the fact that the Constitutional Compact was created by sovereign states that binds them only as sovereign states. The reference to the law of nations, it's not insignificant here, as it indicates that the Constitutional Compact has a character not of a domestic public law, but of international law. And Lincoln flatly denies it, right? In his message to Congress, he says that no state upon its own mere motion can lawfully get out of the Union, that resolves, he continues, that resolves and ordinances to that effect are legally void, and that acts of violence within any state or states against the authority of the United States are insurrectionary or revolutionary according to circumstances. So while for Webster, nullification was an act of breaking the law, binding on all citizens of the United States, secession is an insurrection, right? It is a direct attack on the constitutional order as a whole. It would follow, obviously, from Webster's logic of whole and parts, but Lincoln adds to an interesting twist to that. The states have their status in the Union, and they have no other legal status. If they break from this, they can only do so against law and by revolution. The Union, and not themselves separately, procure their independence and their liberty. By conquest or purchase, the Union gave each of them whatever of independence and liberty it has. The Union is older than any of the states, and in fact, it created them as states. If you will, at the previous junction, we had a kind of a spatial or synchronic relationship between the peoples of the states and the people of the United States. Here we have diachronic or temporal, if you will, right? The Union is a creator of the states. States do not exist without the Union. If it were not for the Union, they would remain colonial subjects at the whims of the crown. And whatever they were before independence, they were not states, and they became states only because the Union shook off British tutelage and turned them into states. This means that states owe their existence to the Union, right? And another visual aid, right? So for Davis, and again, like dark brown states, light brown Union. No, this is not again, but this is what it means in this slide. For Davis, states precede the Union, and when they create it, they never become one. They only act jointly through the general government, and for this reason, secession is possible and legal, and it does not affect the compactual bonds binding the remaining states. In fact, given the attacks on slavery by the Northerners, slavery, which is the foundation of the Southern social, legal, and political order and identity as the South, war against remaining in the Union is an existential war to remain Southerners, right? Lincoln inverts this diachronicity or this temporality of the compact theory, right? In Lincoln's formulation, the Union precedes the states. The Union is not the creature of the states, but the other way around. It follows that the states do not have and never had any independent existence of their own, and for this reason, the peoples of the states were first the people of the Union, and only after that they became the people of the peoples of the states. And for this reason, the Union either remains unbroken or collapses completely. That's why there is one. The U.S. Constitution binds the entire nation together, and if the part wants to secede, it mounts a challenge not to its membership to the entire Union, but to the to its membership to in the Union, but to the entire constitutional order of the Union, right? So from this perspective, the war against Southern secession is an existential war to preserve the nation and to preserve the Union, right? So the question is, where does it leave us, and why does it all matter, right? So there are different and diverging and mutually exclusive interpretations of we the people and a more perfect union, right? So Lincoln, in his inaugural address, states flatly that the Union is much older than the Constitution, right? It means that the Union, the people of the United States as a whole, established Constitution, right? But it also means that the Constitution is the emanation of the pre-existing unity of American people, right? The other position, right, is best phrased by Calhoun in the posthumously published Discourse on the Government and the Constitution of the United States, which he was drafting in 1850. And he writes, "There is indeed no such community, politically speaking, as the people of the United States. And since there is no such thing, and it never existed, it could have not created the Constitution, nor does it participate in the administration of the United States." If you want to refer it to some institutional setups, right? So from this perspective, the House of Representatives, right, is not a people's chamber of the Congress, as opposed to the chamber of the states, meaning Senate, right? But it's also a states chamber, but in which states are represented according to their population and not equally, right? So that's, while Calhoun denies the existence of the people of the United States, right? Lincoln, in his description of the people of the states who do not have any meaningful political existence outside the U.S. Constitution, suggests that that the only real political existence is has the people of the United States. And this this translates into different meanings of the more perfect union, right? The stated purpose of the Constitution as expressed in the preamble, right? If the destruction of, and this is a quote from Abraham Lincoln, if the destruction of the Union by one or a part only of the states be lawfully possible, the Union is less perfect than before the Constitution, having lost the vital element of perpetuity. So in other words, right, a more perfect union, right, is about extending the perpetuity expressed in the Articles of Confederation and Perpetual Union, and it's about more unified government created by a constitution that reflects properly and adequately reflects the unity of the American people, right? For Calhoun, by contrast, a more perfect union means establishing a more effective instrument for cooperation between states and peoples of the states, right, with firmer legitimacy. And he states it in the following way. It, meaning the United States, became a union in consequence of being ordained and established between the people of the several states, by themselves and for themselves, in their character of sovereign and independent communities. And he continues, to have gone a step beyond would have been to consolidate the states and not the union, and thereby to have destroyed the latter, right? The Constitution is a compact, and this compact requires, right, separate existence of the peoples and the states. If you erase the peoples and states, you erase the union. And this, importantly, right, this separate existence is phrased in the language of sovereignty and sovereign rights of states, right? And the consequences of this kind of thinking are clear when Jefferson Davis speaks of the right to secede from the Union as stemming from the principles of international law. With this statement, Davis effectively reduces the Constitution to an international law treaty, right? And it is against this background that the concept of the federal state achieves its maturity with Lincoln's vision of the Union. The key is the conception or idea or interpretation of constituent power that lies at its foundation, right? And from which are derived all other crucial features, right? The constituent power is a unitary people who establish the national constitution, and through this constitution they empower states as constitutionally entrenched and autonomous units who nonetheless have their existence only within and through the Union, right? Federalism, in this view, is reduced to the vision of two governments over one territory, with the semantic core of federalism, fedos, meaning compact, completely eliminated. But given that political concepts are polemical concepts, this far-reaching interpretation is not inconsequential because it pushed Calhoun and Davis to draw their far-reaching consequences, right? Not only in their case, not only the existence of the people of the United States is flatly denied, but also the character of the Constitution is virtually reduced to the question of international law, right? But there is a thing that, despite all their differences, right, Lincoln and Calhoun/Davis share a thing in common, right? In fact, both Lincoln on the one hand and Calhoun and Davis on the other operate under the assumption of monism, right? The people can only be one and unitary, right? For Lincoln, this is a unitary character of the people of the United States. For Davis and Calhoun, it is the unitary character of the people of each state. These are, by necessity, mutually exclusive visions, right? But there is a cost to this either or logic, because these visions are not only mutually exclusive, but they are also exhaustive of the imaginable possibilities, right? Together, they crowd out possibilities of imagining something that lies beyond this binary distinction, right? For example, a union that would mean both the people and peoples, right? Or the people that is also the peoples. The pluralistic vision in which the unity does not exclude plurality is rendered, becomes a contradiction in terms that both theoretically and practically requires resolution into either of the two options, right? And we see those contradictions and the problems that come up with it, right, with contemporary debates regarding the democracy, regarding democracy in European Union, for example. And if I argue, images of the world like switches determine the tracks of human action, then this binary distinction crowds out the political possibilities ahead of us, right? But I promised something about contemporary politics in the United States as well. I believe that the conceptual reconstruction that I gave can help us formulate hypotheses about American politics. For example, the presence of the Dixie Cross or the Southern flag, the flag of the seceding South on the Capitol during the events of January 6, 2021, right? Why a symbol of people who argued for peaceful separation instead of violent takeover of Washington ended up during violent attack on central institutions in Washington, right? How on earth is a symbol of going separate ways if we disagree used in a situation when people want to impose their own ideas in Washington, right? Well, it has to do with the effects of civil war, right, on how people conceptualize in constituent power and therefore secession, right? Because Civil War effectively decided that compact theory is not applicable to the United States, and that secession is illegal, mostly because it reconstituted the United States as the federal state, right? It does not mean that the secession or the issue of secession as such disappears, right? In fact, all opponents of secession as a legal right actually recognized it as a revolutionary, extra-constitutional right of the oppressed to rise up against tyranny, including Lincoln, right? This was not the language of Calhoun or Davis, because they believed that what they were doing was legal. But this is the only acceptable language under the idea of the federal state, right? So we can hypothesize that within an imaginary in which decision is admitted only as a revolutionary right, the symbol of any secession becomes also a symbol of resistance against tyranny. So by conflating the two meanings of secession, a legal right under international law and revolutionary right, the meaning of the Dixie Cross is itself whitewashed, kind of pun intended, right? And whitewashed not in the sense that its original meaning, the regime of slavocracy and white supremacy, is deleted, but rather that the two are combined, right? The former serves as means of sanitizing the latter meaning the meaning of the regime of slavocracy, while the latter serves as a dog whistle for white supremacists. And I am not talking here about history, not hate, or heritage, not hate crowd, right? Who see the Dixie Cross as a historical artifact. I am talking about associating the symbol of secession in the explicit name of preserving slavery with a set of values that in American imaginary are unequivocally positive, right? That is the American Revolution. And this, I believe, and if I'm right, and as I said, this is just a hypothesis, right, can lead to increasing use of this kind of symbols and of this kind of ideas in order to further racist goals, or can be used by racists in order to pursue their goals. And that's it.